Uttarakhand UCC bill. Do you really know these things about UCC, its history and the loopholes that it has?
The government's role in bridging these gaps and ensuring the preservation of women's rights cannot be overstated. As we dissect the intricacies of the Uniform Civil Code in Uttarakhand, one of the central debates that revolved around was the dichotomy between marriage as a ceremony and marriage as a contract. This distinction holds profound implications for legal frameworks and societal norms. The language of the law is indeed intriguing, particularly in its treatment of marriage registration and exemptions based on customs and usage. While the UCC acknowledges the sacredness of marriage ceremonies in Hindu personal law and the contractual nature of marriages in Muslim tradition, it introduces exemptions that may seem perplexing at first glance. The provision allowing for polygamous relationships based on customs and usage raises questions about its applicability to communities where polygamy is practiced as tradition. However, the law later clarifies that such customs and usage must not violate public policy or morality, granting the states the authority to determine their legality. When it comes to divorce, the UCC takes a clearer stance against polygamy, empowering women to seek dissolution of marriages if their husbands have contracted multiple marriages. This provision marks a significant step towards addressing the rights of women in polygamous relationships. After the code has been passed, polygamous relationships are illegal in Uttarakhand. Any woman in a polygamous relationship in Uttarakhand can now claim divorce on these grounds. The law is talking indirectly about the right of the women to divorce their husbands if they have married more than once. However, the law does not directly stipulate legal grounds for maintenance of these rights. Therefore, the loophole in legal implementation of the personal laws have not been changed much here. In terms of property distribution and inheritance, the UCC states that the distribution will be primarily first between the spouse and the children. The first rule is specified as every surviving spouse of the intestate shall take one share. The rule 2 is that every surviving child of the intestate shall take one share. The law says that when it comes to inheritance, there are disqualifications upon remarriage, that is, when a widow gets married again in the lifetime of the intestate, such widow shall not succeed to the state of the intestate. The only way a child can be disqualified from inheritance is if the child died before the death of the intestate. The law, therefore, once again maintains the equal rights of daughters in inheritance. However, one aspect is very crucial here. Particularly in the Hindu Succession Act, daughters were given equal rights to share in property. However, the law was amended in 2005 to exclude scheduled tribes. This amendment was questioned by the Supreme Court in December 2022. The Supreme Court had questioned that when a daughter belonging to a non-tribal is entitled to the equal share in the property of the father, there is no reason to deny such right to the daughter of the tribal community. Female tribal is entitled to parity with male tribals. The court had noted that to deny the equal right to the daughter belonging to the tribal community, even after a period of 70 years of the Constitution of India, under which right to equality is guaranteed, it is high time that the central government looks into the matter and, if required, amends the provisions of the Hindu Succession Act, by which the Hindu Succession Act is not made applicable to the members of the scheduled tribes. It is high time that the central government looks into the matter and, if required, amends the provisions of the Hindu Succession Act, by which the Hindu Succession Act is made applicable to the members of the scheduled tribe. With no exceptions, the UCC in Uttarakhand legally stipulates equal distribution of property amongst all members of the community. However, this still is an issue at the pan-India level. There is just one aspect of inheritance that the law still needs to bring attention to. This is the substantive idea of equality. For example, within a Hindu joint family, a daughter upon marriage usually leaves the natal house and starts living with her husband and his family members. The son does not. The consequent treatment of married daughters, as now said to be belonging to the husband's family, impairs their rights within the natal family. This is the reality of countless women today in India. For example, in Haryana and Rajasthan, daughters are made to sign a relinquishment deed, which is called the Hak Tyag, by which they relinquish their rights in ancestral property in favor of their male family members. While such declarations are supposed to be voluntary, women are often subject to overt and covert pressure tactics by their brothers in particular. Theoretically, they can dispute the validity of the deed on the ground of fraud, coercion, threat, and intimidation by their family members. But practically, it is a Herculean task. In its implementation and procedures, the legal system needs to make the procedure of redressal in terms of exclusion from property easier for women, so that more women feel comfortable in going to court to assert their rights. Therefore, any future law reform on property rights of women would need to confront rigid patriarchal and cultural norms, beliefs, practices, and biases. After all, giving women a share of the family property will consequently reduce the property shares of the male members, which they are bound to resent, resist, and revolt against, given the patriarchal mindset that only men can own and manage property. It requires key interventions in terms of reviewing the revenue codes, training the staff that implement the law, and oversight mechanisms at the state level to ensure effective implementation. Any UCC needs to take this into account. Any discussion on UCC needs to address these existing loopholes in personal laws today. Now coming to the elephant in the room, live-in relationships. The code says that it shall be obligatory for partners of a live-in relationship within the state, whether they are a resident of Uttarakhand or not, to submit a statement of the relationship to a registrar within whose jurisdiction they are living. It should not be denied that considering the changing nature of families in India, with many couples opting for live-in relationships, a basic legislative structure on this is not a bad thing. However, the Uttarakhand UCC takes it a step ahead. Any resident of Uttarakhand staying in a live-in relationship outside the territory of the state may also submit a statement of live-in relationship to the registrar within whose jurisdiction the resident ordinarily resides. Meaning, if you are a resident of Uttarakhand and you have moved out of the state to go in a live-in relationship anywhere in India, you have to still inform the registrar. The reason why I said that extending this notion of live-in relationships within some sort of a legislation is good is because now children of live-in relationships have been considered as legitimate children of the couple and given rights of inheritance under the Uttarakhand UCC. The code says that live-in relationship will not be registered on only 3 grounds. If one of the person is married or they are already in a live-in relationship with somebody else, if one person is a minor, the consent of both parties are important and should not be obtained by force or coercion. The third aspect is that it should not be against customs, public policy, and morality. What is the meaning of customs, public policy, and morality has not been defined in this section. It also stipulates that if you are under the age of 21, then the registrar reserves the right to inform and gain the consent of your parents or guardians. After living together for more than a month, if you do not inform the registrar, then you will be punished with an imprisonment of a fixed term which may extend to 3 months, or with fine not exceeding 10,000 rupees, or probably both. If a woman is deserted by her live-in partner, she shall be entitled to claim maintenance from her live-in partner, for which she may approach the competent court having jurisdiction over the place where they last cohabited. Now, the aspect of certain legislations being extended to live-in relationships is a good thing considering the evolving nature of families in India. However, the law completely overlooks the notion of why couples are opting for live-in relationships sometimes. It is to understand their own dynamics, it is to sometimes denounce the institution of marriage, and to not bring in the entire legislation of socio-economic, societal norms and pressures and customs. Now, when the law is codified in such a detailed manner, it somehow completely has a mismatch from why couples are actually opting or even wanting to go into live-in relationships. The state still reserves the right to address and add anything to the live-in relationship legislation through the Uttarakhand Gazette.